Hello guys, welcome to the YouTube channel. I'm Sufi Hot. I hope you'll be fine. This time, talk about federal court says Sensible Corporate Transparency Act is unconstitutional. An Alabama federal court ruled that Corporate Transparency Act (CTA) is unconstitutional, leaving the policy's future unclear. In 2021, Congress enacted legislation mandating companies to share their identities and information about beneficial owners. The law, which went into effect in January, was designed to combat illicit activity, including monetary laundering, tax fraud, and terrorist financing. Violations would lead to a fine of up $10,000 and 2 years in prison. The US administration officials defined the bills as a vital tool for law enforcement and national security agencies to crack down on criminals, corrupt individuals, and other players who may exploit the US financial system for legal pursuits. In doing so, this rule will make it harder for criminals, organized crime rings, and that elite actors to hide their identities and launder their money through the financial system, said Treasury Secretary Janet Yellen in a September 2022 statement. Critically, this rule will not greatly further our administration's work to fight corruption and its corrosive effect on our democracy and rule of law, both at home and around the world, according to summary judgment in the case of National Small Business United v. Yellen, the U.S. District Court for the Northern District of Alberta determined that CTA was unconstitutional opinion on March 1st. Judge Lylesburg asserted that while the intentions behind the law are sensible and praiseworthy, the federal government raising for the CTA are not supported by precedent. The US government presented three main arguments in court. The first contention was the Congress could enact the CTA because their foreign affairs power. The second is that the CTA is a necessary feature and function of its taxing power. The final reason is that the CTA is a proper tool under the Commerce Clause. In this summary, the federal judge opined that CTA exceeded the Constitution's limit on legislative branch, adding that it does not meet the criteria of congressional powers in the Commerce Clause. The plain text of CTA does not regulate the channels and instrumentalities of commerce, let alone commercial and economic activity. Judge Burke opined because the CTA does not regulate commerce on its face, contain the jurisdictional hook, or serve an essential part of our comprehensive regulatory scheme. It falls outside Congress' power to regulate non-commercial interstate activity. That said, the court contended that the Congress could have passed legislation that would have won a constitutional challenge, citing two cases in 1946 to 1974. These it highlight how highly Congress could have written the CTA to pass constitutional muster. According to the court, neither case would bar Bar Congress from imposing the CTA's disclosure requirements for state entities as soon as they are engaged in commerce or from prohibiting the use of interstate commerce to launder money, evade taxes, hide, elect welder, and defraud employers and customers. You can watch all the latest news from my channel and subscribe my channel for latest updates and stay connected with me. Have a nice time. Goodbye.